Everyone. My name is Nick Marricco. I am an education attorney here at Tully Rinckey, and I'm joined here by my colleague, the great Sivan Zak. In
Hi,
today's
everyone.
web, hi,
Sorry.
hi Sivan, how are you? You're doing good, Sivan. How are you? So we are going to discuss the differences between 504 plans and IEPs. The differences between 504 plans and IEPs. So we're going to move on to the next slide. Great. And big shout out to Sivan who created this excellent PowerPoint. Sivan, the PowerPoints are excellent as always. So an overview of what we're going to talk about today is whether your child should obtain an IEP or whether your child should obtain a 504 plan. And really the difficulty in assessing what your child needs to thrive in the educational setting. Both plans really do exist to accommodate and serve children with disabilities, but there are key distinctions and key difficulties that parents face when trying to get either document. And now the biggest difference, I mean, they are two completely different things. They are literally apples and oranges. But the key difference is what law governs 504 plans and which law governs IEPs. 504 plans are governed by Section 504 of the Rehabilitation Act of 1973. And I bet you cannot say that 5 times fast. And this is a civil rights law that is developed to prohibit disability-based discrimination by schools that receive federal funding. Spoilers, almost every single school receives federal funding. IEPs, on the other hand, are governed by the Individuals with Disabilities Education Act, which is another law I bet you cannot say 5 times fast. And the acronym for that is the IDEA, the IDEA. So you have Section 504 and you have the IDEA. Again, Section 504 is Section 504 of the Rehabilitation Act of 1973, and the IDEA is the Individuals with Disabilities Education Act. Now, we are going to move on to the next slide. Now, we're first going to discuss 504 plans. Again, these are governed by Section 504. Now, it's a federal law that protects students with disabilities when the disability is not necessarily academic. Now, you may ask, Nick, what the heck does that mean? That's a great question. It's if there's a disability that has a major impact on has an impact on a major life activity, but it's not really academic in nature, you're probably looking at a 504 plan, and we're going to discuss that more in depth. Now, 504 plans apply to all schools that receive federal funding. Kind of a little side story. Sivan and I, the great Sivan, had a very unique case recently that we were able to resolve for the client. This client attended beauty school, and the client needed a 504 plan. So Sivan and I took the case and we contacted the beauty school. And we informed the beauty school, hi, beauty school, our client, we want to have a 504 plan meeting just to discuss giving our client a 504 plan. And they responded that they do not have to do that. To which I responded, and Sivan could, all this is true. I responded via email at like 11:30 at night, citing the law and citing exactly why they needed to give my client a 504 plan. And magically, within a few weeks, the 504 plan was drafted, and our client's doing very, very well academically. It looks like she's going to get her license, her cosmetology license, and I'm hoping she does men's hair because I definitely need a haircut. Now, the reason why Section 504 applied to the beauty school is because the beauty school received federal funds in the form of tuition assistance and basically tuition funds from the federal government. That's how most colleges in the country get 504 applied to them. It's through the federal grant money for tuition assistance. That's how that beauty school was required to give my client a 504 plan. That's why most colleges in the country are required to give 504 plans. So 504 applies to pre-K, grammar school, most high schools, in almost every college, trade school, law school, medical school, dentist school, your PhD program, your master's, everything. So long as the school receives federal funds. If they receive federal funds, they have to give you a 504 plan, assuming you have a disability that has affects one or more major life activity. Now, there is a definition as to which students are entitled to 504 plans, and that's the third bulletin. Now, here is the definition of who's able to receive a 504 plan. Now, this is usually where the argument happens between us and the school. Sometimes it's a school district, sometimes it's some college attorney, sometimes it's an attorney who represents a beauty school. And this is where the disagreement usually lies. Does my client's disability affect a major life activity? That's really where it comes down to. 99% of the time, it's clear that it does, and there's usually no disagreement. But that 1% does happen, and that 1% is very frustrating. Now, examples of major life activities are kind of what you think they are. Walking, seeing, hearing, speaking, breathing, learning. There's another kind of catch-all where it says working. So if you have a disability that affects your ability to walk, see, hear, speak, breathe, learn, or work generally, you might be entitled to a 504 plan. And if you are requesting it for your child and the school district, college, beauty school is saying no, you should definitely give an education attorney a call. Okay? But remember, the distinction here is that the disability may not inherently be academic related. For example, when I was in middle school, I fractured my ankle. I was in gym class. I was doing jumping jacks. I fractured my ankle. Luckily, I didn't need surgery, but I was pretty much bound by crutches and a wheelchair. Had I needed some accommodations in my classroom, I could have gotten a 504 plan to accommodate that because my fractured ankle was not really an academic disability, but it was a disability that affected my major life activity of walking and standing. And actually what happened was I was given homebound instruction. So I was a tutor would come to my house, I would get my lessons there. And I was also late to class a lot, and I'm the only kid probably in the country that had homebound instruction and still found a way to be late to school. But that was the accommodation that I was given. It was homebound instruction because my fractured ankle affected my major life activity of walking. In that scenario, again, a fractured ankle doesn't really affect my ability to learn. It affects my ability to walk. So I had an accommodation to get homebound instruction. So the gist of it is, if it affects your ability to learn, it's most likely going to be an IEP, which we'll get to. If it's more of a physical impairment that, again, makes your life difficult, it's most likely going to be a 504 plan. And again, this applies to students in middle school, high school, grammar school, pre-K, all the way up to post-grad, law school, med school, everywhere, if they receive federal funds. So we're going to move on to the next slide. How do 504 plans apply specifically in schools? Now, again, if the disability substantially limits a major life function or activity, which could include learning, you are entitled to a 504 plan. Now, if your child is excluded from an activity due to their disability, a 504 plan would be required to provide them with accommodations and modifications to access both academic and extracurricular activities. The example from before, I fractured my ankle, I couldn't walk. I had to take the bus to school. I lived in the city. I couldn't get to school. My school gave me a tutor to come to my house. That was an accommodation. Now during that time, I wasn't doing gym class, so I presume, I was like 12. I wasn't at the 504 plan zealously advocating for myself like we do our clients today. I presume there was some modification for my physical education. Because how could I do physical education if I was using crutches? So there had to be some modification to my gym class. And Sivan could testify to this. That's most of the 504 plans we see where there needs to be some modification to classes, including gym. Now, that brings us to the next bulletin. Now, the way we could accommodate physical education is by doing something that may not necessarily be a sport, but maybe keeping score of the game, maybe doing essays. These are accommodations and modifications that can be provided in a 504 plan. And Sivan, I see you're unmuted.
Yeah, I had another case example for a 504 plan that perhaps you wouldn't think would apply for a 504 situation. But we recently had a client who came to us where her child had an extreme and severe allergy to food. And because of that allergy, we had to coordinate with the school district about developing a 504 plan for the student so that she could remain safe in her classroom. And we were able to do that by ensuring that there were EpiPens and a plan of action for anaphylaxis if that took place in the classroom, and to ensure that there were no, allergens brought into the classroom, things like that. So when you think about a major life activity like an allergy that can obviously impact, her livelihood, this is a really beneficial plan that can help ensure that the child can access her education without any sort of barriers and with safety of her life in mind. So this really does apply to so many different aspects, and it's not just a physical impairment like breaking your leg. And while that definitely applies, it can be something like an allergy as well.
Great point. And actually, the federal government has found that allergies are a form of disability that would require a 504 plan. So as
Yeah.
Sivan said, in this scenario, the child needed a tree, was it a tree nut-free classroom?
Yeah, it was a fully nut-free classroom, and we were able to obtain that. It wasn't easy, and the school definitely pushed back, but we were able to obtain it because, as Nick said, having an allergy does qualify as a disability under the law.
Yeah. And Sivan, you make a great point. Now, some people who are listening and maybe are good friends at the New York State Parent Teacher Association are listening, and they may think, why would you have to fight to help protect a child's allergy and potentially having a fatal reaction to allergies? We'll tell you, school districts oftentimes want to do the bare minimum. And oftentimes, attorneys like us have to get involved to remind them of their obligations. So in this scenario, the client was requesting a totally nut-free classroom, and the school wasn't giving it to her. It was only until we got involved that we were able to secure that for her. So something as minor as that, just making sure there are no peanuts in the class, turned out to be a fight. I remember that case. It turned out to be a fight. And we'll get to this later, but if the school district would have said no, it would have been very difficult for us to overcome that. So we're glad that we were able to have that resolved without the need for further and very expensive litigation. So the next slide, please. So the students that the 504 plans apply to. So we have a list here that if your child fits into one of these categories, they may qualify for a 504 plan. Now, the most common diagnosis that benefits from 504 plans are students with ADD or ADHD. And the most common types of accommodations and modifications would be taking a class in a separate classroom or taking a test in a separate classroom, extended time on an exam, sitting closer to the teacher during class. We see those all the time. Those are kind of like the garden variety Section 504 plan accommodations for students with ADD or ADHD. Now, temporary physical disabilities, like me, I fractured my ankle, I can't go to class. How's I going to get to class? We live in the city. I took the bus and the train. I couldn't go. So school let me receive homebound instruction. Students with mental health issues. Oftentimes, they may need to take certain medication throughout the day. That would require them to leave the classroom. That could be a type of modification and accommodation. Maybe students with mental health issues could benefit from taking their exam in a separate location. Maybe extended time on their exam. Maybe sitting closer to the teacher to prevent overstimulation from their peers. There's a slew of different services, modifications, and accommodations that students with mental health deficiencies can qualify for. Students returning to school after an operation. Think about it. If a child has knee surgery, they want to go back to class, what are we going to do for that student? There are numerous types of accommodations and modifications that type of student can receive. Students with asthma, it would be access to their inhaler anytime they need. Maybe having staff that are trained in the classroom to administer the inhaler if needed. The most obvious one is an accommodation for gym, physical education. You can't hold that student to the same standard as their peers without asthma. That would be unfair. Students with hearing impairments, that could be sitting closer to the teacher. That could be a headset with a microphone given to the teacher. Students with neurological impairments, it could be additional training for the faculty on that specific impairment. It could be a gym modification. It could be sitting closer to the teacher. Students with severe allergies, like the example we just gave before. Students with diabetes, ensuring they have access to their insulin, making sure that the teacher is trained on how to administer the insulin. These are all things that we can get done in 504 plans and type of accommodations, modifications, and services that parents are entitled to and are entitled to receive for their child. Now, the 504 plan must address what the services, accommodations, and modifications are going to be. In the 504 plan, it goes without saying, must be in writing. They just can't verbally tell that to you. It has to be in writing. Now, this has to be in writing, and it has to, in the 504 plan, must clearly explain what the services, modifications, and accommodations are going to be. Now, if you're unsure whether your child's disability may qualify for a 504 plan, feel free to give us a call or call another qualified education attorney. These are children of all ages, whether you're or students of all ages, whether you're in pre-K or you're in college, you may need some extra assistance to get equal access to your education. And the law allows you that equal access. And you may ask the school district or the college for the help. They may say no, but the law oftentimes requires them to say yes. So again, you should call an education attorney to see if what you or your child is going through could qualify you for a 504 plan.
So sorry, Nick. I just wanted to interject quickly because something you brought up that's really interesting and a big comparator between 504 plans and IEPs is actually the form in which they have to be drafted, right? So while 504 plans, we always recommend that you receive them in writing. There isn't like a specific form that they need to follow. So realistically, as a 504 plan could just be, modification and how it's implemented, or just a description of how, they're going to accommodate the student. Whereas an IEP is very structured and it has to follow a very specific form. And we'll get into that a little bit more. And we have done articles and webinars on this in the past. So if you are curious about seeing that, make sure to take a look on our website. but there is, very specific form that the IEP needs to follow. And so this is a very big shift because you're not going through the same exact process. You're not necessarily meeting with a full-blown team to develop an IEP or, sorry, a 504 plan as you would an IEP. So those are just some interesting comparator points to add. So moving on to IEPs, as we kind of have touched on a little bit as we've gone through this process. But as we mentioned, they are governed by the Individuals with Disabilities Education Act of 2004, or the IDEA, as it's very commonly referred to. And under the IDEA, for a student to qualify for an IEP, they have to have a very specific disability classification that's defined by law. So, typically a student receives a disability, diagnosis from a physician. But within the IDEA, for a student to be classified with an IEP, one of their, their disability has to fall within a category of disability classification. And we'll touch on that a little bit more, but there are very specific disabilities that need to be impairing a student's access to education. And that's a very important point, is that it's not necessarily like a 504 plan where it just impacts a major life activity. For a student to be eligible for an IEP, it has to actually impact their access to education. And, for an IEP to be developed under the IDEA, the IEP has to address special education services that would allow the student to actually access their education. And we'll definitely get into that a little bit more as well. But similar to 504 plans, students are eligible for IEPs when their disability impacts their access to education and learning, as we've discussed. So IEPs are developed by a team called the Committee on Special Education. And that team is comprised of teachers, clinicians, the parents, and if you as the parent want an advocate or an attorney to come with you, you are absolutely permitted to. Though I will note that advocate or attorney is not necessarily considered part of the CSE, but they are there and able to assist you with making arguments that you may have prepared beforehand, or they're there to advocate on your behalf. So an IEP, as I mentioned earlier, has to follow that very structured form. And that includes measurable goals that the CSE team needs to develop, accommodations and modifications, similar to what we talked about on 504 plans. Those can apply in IEPs as well. How to measure that progress that a child is making throughout the course of the year. Related services, which are in addition to accommodations and modifications, and any transportation needs. Sometimes students require special transportation. That may apply to a child who's in a wheelchair. That requires, obviously a bus with a lift, and special seatbelts that may apply to the bus. So these are all things that can be addressed in the IEP. You can go to the next slide, please. Okay, so what students do IEPs apply to? As I was mentioning earlier, for a student to be eligible for an IEP, their disability has to fall into one of 13 disability classifications that are outlined by the IDEA. So it's important to note that obviously, this list that you see here are not the only disabilities that your child can have in order to be eligible for an IEP. But no matter what disability your child is diagnosed with, it will fall into one of these 13 categories, because these categories really set the framework for the IEP and set the structure for how the services will be recommended to ensure what goals will be on the IEP. So for example, if a child is classified as a speech or language impairment, obviously it would make sense that they would have a speech goal, speech language therapy, all of those types of services that accommodate that disability classification. So making sure that you choose the correct disability classification is crucial to the rest of your IEP development. We recently had a case on this where we fought tooth and nail with the CSE team strictly on the actual classification that the child would receive, because it really impacted the rest of the services on the IEP. So for instance, if your child has an autism classification, then you're entitled to additional services than you may be on an other health impairment classification. And that would include things like parent counseling and training, where you as the parent could go in once a month and receive specialized training on, assisting your child with autism in the home setting, things like that that may be included. So just to quickly kind of go through these disability classifications, there's autism, deaf and blind, deafness, emotional disturbance, hearing impairment, intellectual disability, multiple disabilities, orthopedic impairments, other health impaired, specific learning disability, speech or language impairment, traumatic brain injury, and visual impairment, including blindness. So as you can see, some of these are much more pointed and much more specific. You can pretty much deduce that if your child has autism, they'll likely be given an autism classification. But, there are certain disability classifications that are much more open-ended, and that could include other health impaired, specific learning disability. So if you have any issue with the CSC on determining what the appropriate disability classification would be for your child, we always recommend contacting an education attorney. Nick and I do this on an almost daily basis, and it really can frame the way your child's IEP is drafted. So we always recommend making sure you really brush up on what these classifications are, and choosing the right one is the most important part of the IEP. Do you have anything to add, Nick?
No, perfect. Perfectly said.
Great. Okay, we can move on, Taylor. So what are the special education services that are on an IEP? So if a student is found eligible for an IEP under one of the 13 classifications, the CSC has to develop an IEP to include a lot of different things, but these are really the three that sort of hit the nail on the head. We do have a lot more information on the specific pieces of the IEP in other webinars and articles, so definitely feel free to check those out or reach out to us if you have any questions or need to talk anything through. But these 3 points are really what's most important, and I would say, aside from the classification, the 3 points that are most contentious in an IEP drafting process. So specially designed instruction needs to meet the unique needs of the student. So that would include anything that is unique to the child that would be found through evaluative data, through teacher or parent reports, through any other reports that you may have. So if your child attends an extracurricular activity and that person has information to share about what they think would be beneficial for the student, anything like that needs to be included in the child's IEP. Now, there are always limitations, right? Obviously, parents want the absolute best for their children, and we cannot blame you for that. Of course you do. But, the school district doesn't have to provide every single thing to maximize their education. They just have to make sure that children can access their education. Though it's always best to argue for the most, because in some cases, the absolute most is what they need. But those sort of things that are unique to your child really do need to be included in the IEP. So another portion of the IEP that's really necessary are the accommodations and modifications. Now, these are very similar to what we discussed in the 504 plan section of the webinar, where you're thinking of this as really 2 separate pieces because they are different. Accommodations are changes in access to the curriculum and instruction, while modifications are changes to the expectations of the student when engaging with the curriculum. So I provided a couple examples for this to break it up because I know that sounds very confusing, and the first time I read it, I was confused as well. So an example would be a child has a visual impairment, so all textbooks and assignments are read to them via a computer system. That would be an accommodation because that changes the way your child accesses their education and instruction. So it gives them another medium, another mode to read the textbook and obtain the information and access their education. So another example would be a child has a learning disability that impacts their ability to take tests. So the child takes the class on a pass-fail basis, right? So this would change the expectations of the student when engaging with the curriculum. So it doesn't necessarily change the actual curriculum or their access to it, so another way that they engage with it. It really just takes away that sort of stressor for them, right? So this is a modification in their expectations. So they don't have to get 100 on the final grade or the final test to get an A in the class. Like, they don't have that stressor on them. And then another aspect of this are related services. And I know I said that these are the three most contentious, but of the three, this is probably where we see the meat of it all. So related services are defined as any service that assists the child with a disability to benefit from special education. That is incredibly broad. But what we see is that these typically include things like speech language therapy, occupational therapy, physical therapy, and more, counseling, things like that. Where a lot of the contention comes in is the frequency. So how often that happens. Sometimes the CSE recommends that it happen 1 time a week, but you believe that your child requires speech language therapy 3 times a week to address their needs. So a lot of times that, can become contentious. But this is really where we see, the most sort of pushback on an actual IEP. Okay, we can move on. So who ultimately decides whether a 504 plan or an IEP is appropriate for the child? This choice is made by the Committee on Special Education. If you have a child with a disability, you've probably been through this process. You know what it's like. You meet with the CSE, everyone kind of goes around the room and discusses what they think is best, talk about the child, and go through evaluative data. If recent evaluations have been done, you'll go through those, and everyone sort of discusses what they think is best for the child. If an IEP is chosen, obviously you'll go through the whole process I just discussed with the classification, the services, accommodations, making sure all of that is squared away. But if the 504 plan is found to be appropriate, that's typically a shorter meeting because you don't go through all of the processes that I just discussed. But you will still meet and get a chance to portray what you think is best for your child and really discuss that with the team before developing a 504 plan. So, in either meeting, in either scenario, the team will review the evaluative data. They'll collect reports from teachers, parents, anyone else that may be involved, and they'll discuss what would benefit the student best. Okay, we can move on. So obviously, all can be great and the plans can work out really well and you can have no problems with it. And I hope that happens for every single one of you. Unfortunately, that's not the reality of what we see. And Nick and I wouldn't be in business if that was the reality. So what happens if you disagree with the plan that the CSE develops? So if you disagree with the CSE team recommending a 504 plan or an IEP over the other, or you disagree with the contents of either plan, you should immediately contact an education attorney. And the reason I say that is because I think a lot of parents try and go through this process on their own, and they don't realize the intricacies, the complexities, the just headache that it can be to fight the school district when trying to get these things fixed. And on top of working, caring for your families, and taking, those things that are priority, it's very difficult to go up against a beast like a school district. So we always recommend that the first thing you do is contact an education attorney, even if just to give you some advice. It's really crucial that you do so because there are a lot of things that you have to do in a very timely manner. They have to happen quickly. If you miss the deadline, your whole case could be thrown out and you don't want that to happen. So, some options can include reconvening the CSE meeting, so you can request that the meeting take place again, and sit with new information or just express your disagreement to the CSE. And one thing I will note with this is that at any point in time in both the CSE IEP meeting or a 504 meeting, if you disagree with something right then and there, note it. tell the CSE you want your disagreement noted on the document, so that if you go into, due process down the line, if you have to, go through any sort of adjudicative process, the last thing you want is them saying, well, you agreed with it at the meeting if you didn't. So I always tell parents to always note your disagreement. So aside from reconvening the CSE meeting to develop a new plan, you can obtain private evaluations. And there are something called IEEs, I always mess that up, independent educational evaluations. And those are evaluations that you can obtain at public cost. So the school district would have to pay for a provider of your choosing. This is a really great tool for parents, and we've covered this in a few different articles and webinars, so I recommend you take a look at those if you're in this situation. But obtaining private evaluations with an evaluator of your choice can be a great tool that you use in these scenarios, because what you're doing is bringing in a third party, someone who is not involved with the school district, to conduct evaluations of your child, collect data, and bring a new set of information to the table. If you obtain a private evaluation, the Committee on Special Education has to consider it. They have no choice. They have to take a look at those documents and determine whether or not they change anything for the IEP. And we see that they do all the time. The data that is collected by the school district does not line up with what a private evaluator brings to the table. So we always tell parents that if you're in this situation, you disagree with what the CSE is recommending, and you think that, their representation of your child in the evaluations is not accurate, to get a private evaluator and have another set of eyes on the situation. So in addition to those two, you also have the option to file a due process complaint for IEP process, and then there's an Office of Civil Rights complaint for the 504 process. That is a much more adjudicative process. So, for IEPs, filing a due process complaint is, developing a complaint, filing it with the state, having a hearing officer assigned, and going to hearing. That includes discovery, testimony, the whole 9 yards. The Office of Civil Rights is a more federal investigative office, so they'll investigate your claims. They may meet with you, but it is a very timely process. It takes quite some time for them to get back. So we always try, especially with 504 plans, to resolve the situation with the school district before we have to file any sort of complaint on those. Do you have anything to add about that, Nick?
No.
Okay, great. So we can move on, Taylor. Okay, so I know that was a lot, and we've covered a lot and can go into way more detail. I think if you sat Nick and I down, we could talk about this for 10 hours straight, probably. But I do just want to leave you with a couple points after all of this information. So obviously, determining whether your child should have an IEP or a 504 plan is very complex. It's very arduous, and it can be very straining on families. There's a lot of emotions involved, especially as parents. You want what's best for your children, and sometimes school districts don't provide that. So we understand that it can be very stressful, and we are here to help. And I want to assure you that every client we've had, in these situations, we really do a deep dive with them and go through the whole process and try our very best to resolve the issue so that it doesn't become more stressful than it is. So some students may benefit from accommodations and modifications, while other students just require a much more involved plan. So, a child with a temporary, disabling condition like a broken ankle may just need an elevator pass, or may need access to crutches when they come into the building, or to be on homebound instruction like Nick was. But some students really need assistance with accessing their education, and in those scenarios, an IEP is probably much more appropriate. So while both IEPs and 504 plans are very different, they both ultimately exist to address a student with disabilities needs and allow them to thrive in their educational environment. And, the last point I'll leave you with is that if you think your child may be eligible for either one of these plans, or you have an issue with either plan, or you just need to talk to somebody about it because you don't know what step to take next, please reach out to us. We are so more than willing to help and to discuss. This is both mine and Nick's passions. We love doing this, and I would not want to be doing anything else. So please do reach out if you have any questions, anything to discuss. We're more than happy to help. Okay, I think we're done, Taylor.
There were a couple of pre-submitted questions that I'm going to send over to you both. Additionally, if there are any additional questions, please send them via the chat for our two presenters.
So the first question is, when a child has an IEP, is he or she eligible for 504, or does a parent have to request it? Great question. The answer is no. You have to request a 504 plan. You do that in writing to the school district. Now, what will often happen, and this is what Sivan and I see a lot, we will request an IEP, we'll go to the CSE meeting, and then eventually the school district might recommend a 504 plan anyway. Oftentimes they'll say, come back for a 504 plan meeting. Sometimes we'll just write up the 504 plan then and there. But no, when you receive an IEP, you are not automatically eligible for a 504 plan. Now, is she eligible for one? You wouldn't need one because the services and accommodations you can get in a 504 plan, you could probably just get in an IEP. So you wouldn't really need one if you have an IEP.
Yeah, it would likely be encompassing enough because really the 504 plan, as we discussed, has accommodations and modifications. The IEP has those as well. So anything that you would request in a 504 plan could likely be addressed by the IEP. Now, I will say in a scenario where, let's say your child has a very temporary, physical ailment or something like that, where they need like an elevator pass when they wouldn't normally, maybe you would request a 504 plan in that scenario for like a temporary situation that isn't addressed year round. But otherwise, if it's something that, your child requires all the time and it's not going to change, I would say an IEP is probably sufficient.
Exactly. So the next question is just being persistent with changing a child 504 into an IEP. So especially when there are doctor's notes and it's in the child's best interest to have an IEP. So we see this a lot, and we've had a lot of clients who have been in that type of situation when we'll get copies of email chains. It'll be months of the parent trying to get an IEP for the child, sometimes years of them trying to get an IEP for the child. Now, the best way, each case is different, and depending on the basis for why the doctors are claiming that your child needs an IEP, depending on what those bases are, depends on what your child's diagnosis is. But let's say if an IEP is appropriate for your child, the quickest thing to do is we would file a due process complaint. Make them go before a judge, make the school district defend why they're not giving an IEP for a child. There's also a SEQA complaint, which is a special education quality assurance complaint. SEQA, 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 that you can file, and SEQA could investigate it and make a decision whether or not the school violated state law. One thing that I no longer do this. I always go the formal route. I no longer advise my clients to take like an informal way of resolving these things. I usually go right to the CSE meeting or go right to due process or SEQA. I no longer engage with school districts in emails like that. So it depends. That seems like a very specific situation, but if you feel that an IEP is appropriate for your child, feel free to reach out to us and we can do a consultation. We're more than happy to do a consultation with you. Now, the next question is it true that a student diagnosed with autism does not necessarily qualify for an IEP, only qualifies for a 504 plan? That is not true. That's actually the complete opposite. autism is one of the 13 classifications under the IDEA, which would qualify you for a 504 plan. I'm sorry, would qualify you for an IEP, not a 504 plan. Now, it'd be very difficult for the school district to defend not giving a child that diagnosis an IEP. It'd be very difficult for them to do that.
So the only
Now,
thing
the
I
te-
will, sorry, I was just going to add to that though. You know, the only thing that I will say is that their diagnosis has to actively impact their ability to access their education. So that's the one thing you need to really look at when determining whether or not your child is eligible for an IEP. Because if, despite their diagnosis, if they are able to access their education, they have straight A's, they're doing really well in school, you know, it's possible that the school could make an argument for why they wouldn't give an IEP. I haven't seen that happen personally with a child with autism, but it's theoretically, it could be possible.
yes. Now, depending on the severity of or the amount of your child's needs, it would be very difficult for the school district to defend not giving your child an IEP. It'd be very difficult. But again, my advice, each case is different. I'm usually more in favor of taking the more formal approach, which is formally requesting a CSE meeting, or going right to due process or filing a SECA complaint. I feel like time is of the essence with a lot of these cases. I don't like to allow the district to waste time anymore. So, but for there, no, if your child's diagnosed with autism, there's a good chance your child will qualify for an IEP.
With that being said, thank you everyone for joining tonight's webinar, and thank you both Nick and Sivan for presenting. Tonight's webinar was recorded and a copy will be sent to all attendees either later this week or early next week. I hope everyone has a great rest of their night. Thank you.